All right, thank you for stopping in and watching today's presentation. Today we're going to be going over the 4 documents that every family needs when it comes to estate planning. My name is Scott Hoberg. I'm an estate planning attorney at Deaver and Hoberg, and what I try to do is help families, and particularly young families, build and grow their wealth as well as making the sort of decisions that they need to make in order to protect their families. So we're going to be discussing a number of things when it comes to today's presentation. The first and perhaps most important aspect that these documents are going to assist you with is protecting your family, allowing you and your family to make the sort of decisions that they want to make and the sort of decisions that you feel are in their best interests. As a member of your family, you have the authority and the ability to say what you want and how you want things to be accomplished outside of outside influences. What we're going to be talking about today are ways to avoid decisions being made by individuals whom you've never met or individuals who may not necessarily take into account the values and things that you hold dearly in your life. We're also going to be talking about protecting your wealth. When it comes to family wealth planning, when it comes to estate planning, quite a bit of this is based on what exactly is going to be done in order to preserve your wealth for future generations. A lot of people are concerned about issues involving the estate tax. We're going to discuss that a little bit and perhaps indicate that it may be something that may not necessarily apply to you. But some of the things that you do need to be aware of are the probate process, probate court expenses, as well as other expenses such as Medicaid and the like that can actually serve as a way to perhaps dwindle your assets before you have an ability to pass it on to the next generation. Another thing that we're going to be discussing is protecting your decision making. In some instances, a lot of the documents that we're going to be talking about are documents where you today or you in the near future are going to be able to have a say over what sort of medical treatment you're going to be receiving, what sort of care you will actually want when you are in a position where you may not be able to fully voice it yourself. Documents such as powers of attorney and living wills can go ahead and provide you that sort of autonomy even when you are not able to fully voice it. And we're going to discuss how exactly those decisions are made and what can be done in order to protect your ability to make those decisions. Finally, we're going to be talking about protecting your legacy. This kind of goes part and parcel along with protecting your family and protecting your wealth in order to make sure that you actually have the proper desires in place with your estate plan so that you can make sure that the individuals who are in existence after you pass away able to fulfill what your goals are and what your dreams are in order to allow society perhaps to live a more fulfilling life. Those are some of the things that we're going to be discussing during this presentation. However, there are going to be a couple of things that we're not going to be discussing in terms of the 4 documents that every family needs. Some of these documents include trusts, investments, Medicaid planning specifically, and specific probate court procedures. I will take a moment though to discuss trusts and perhaps disabuse you of a couple of misnomers that you may have about trusts. Unless you are making an amount of money where the estate tax will likely come into play, and in the year 2017 that means that you have an estate worth at least $5 million, $5.4 million if you're an individual, or approximately over $10 million if you are a married couple, you don't necessarily will need a trust based on the dollar amount that you have. However, in terms of the circumstances in your life, you may find that a trust may be helpful. Trusts allow you to do 2 things. They allow you to control property in a specific way after you pass away, and they also make sure that your assets are preserved in a way to avoid other individuals to perhaps lay claim to those assets during your life and even after you pass away. Specifically, some examples for that you may necessarily want to trust would be in instances where you would be trying to avoid what's called ancillary probate. That's a fancy way of saying that you own property out of state, and placing that in trust might be cheaper than having to open up a probate estate in another state, as well as in the state of Ohio. Other instances could be a little bit more specific to your particular family's needs. Specifically, if you have a child with special or unique needs that may require a special needs trust, whether or not you are in a situation where perhaps you will be asking individuals to make sure that a child who may be a bit of a spendthrift to control the distributions of your wealth after you pass away, or something in general along the lines of just asset protection. Those are specific situations where I would recommend consulting an attorney to see if those matters are something in which you would benefit for a trust. But as I said before, trusts aren't something that every family needs, but they may be something that your family needs. We're not also going to be talking about investments. I'm not an investment advisor. I'm not an insurance salesman. I'm not going to discuss exactly what your investments are and how exactly or what exactly you should invest in. I will be discussing briefly about what are probate assets and what are not probate assets as it relates to investments, because frankly that is going to affect how exactly your estate planning documents may work and may work together. We're also not going to be discussing in depth about Medicaid. Ohio just changed some of its Medicaid guidelines, though Medicaid is something that is extremely specific. And if we're going to be discussing Medicaid, that would likely take up the entire hour and even more. So I'm not going to get into that or get into extensive Medicaid planning, just to let you know that it is something where if you are looking into the possibility of perhaps needing long-term care in the future, that you consult an expert to make sure that that is the sort of thing that may be in the best interest of you and your family. I'm also not going to discuss probate court procedures. Probate court proceedings and matters that occur inside probate court are essentially the results of the documents that you have executed as a result of today's presentations. Or if you fail to actually sign those documents, what will happen afterwards. That being said, it's also something that you would not necessarily need to take action on, but rather would be able to have an attorney do it on your behalf later on. So today, I'm going to be stressing most of our presentation over what you can do today in order to take action to make sure that you have these 4 documents to allow you to have the say that you want when it comes to matters in probate court and elsewhere. I will discuss, though, as it relates to probate court, what exactly it is. It is a court that really cares about 4 things. They care about what exactly occurs when somebody is deceased, what estate planning documents are in effect when somebody is deceased. They also have what's called jurisdiction, or the ability to hold hearings over instances where individuals are declared incompetent or are in the process of reobtaining competency, if that's possible. And they also deal with matters involving adoptions. The most important thing when it comes to looking at probate court, though, is to examine what each of these 4 things are. And more importantly, take that into account, that probate court is going to be the entity where if you do not state what your desires are, they are going to be the individuals making these decisions for you. I will say that if you do not have an estate plan already, the good news is that you already have one. The bad news is the state of Ohio has written one for you. And the problem with that is that they've written it under Ohio law, and as we know, law is not updated with the times as much as possible. I would say that Ohio's intestacy statutes are something that would be a throwback to Leave It to Beaver and this whole ideas of a 1950s family, but it goes back even further perhaps and really gets, if you examine the history, starts examining in Civil War times. So Probate court is not exactly the sort of place where you'll be able to get everything to go 100% the way that you want unless you actually say what it is that you want. When it comes to having an estate plan, when it comes to making sure that that's the case, we're going to discuss some of the documents that you will need in order to do that. Now, before we actually talk about the documents themselves, one of the most important things that I try to do when I meet with a client is to try to determine what their goals are. What is the most important thing that matters to you as an individual that has decided it's time for me to examine my estate plan and perhaps create it, update it, or modify it in a way that has been the result of a change in our family. One of those, as I said before, is protecting legacy. It's to make sure that you get what you want done even past the point that you're not able to actually say what it is that you want. Another situation that people try to draft their estate plans is to avoid probate or extended probate proceedings. Probate court takes time. It also costs money, and oftentimes that it is the estate that ends up having to actually pay for it. So as a result of that, quite a bit of your wealth can actually be be lost in the probate court process in terms of the amount of time that's spent if you do not actually have your documents already prepared to the point where it's more administrative than decisive. Another goal is to ease administration. You are not going to be the only person that is going to be involved in your estate planning documents. Specifically, once you pass away, somebody's going to have to actually work to execute those documents on your behalf. You'll want those documents to therefore be clear and have straightforward directions for that individual. Not only that you get what you want, but also that your family member, in all likelihood, who will be the person that will be administering your estate, or a close and trusted friend, is an individual that knows what they're doing and is able to cope with what will likely be a stressful situation. You know, we've all had family members that have passed away, and we all know what that process is like, particularly if we are the individuals that have to cope with planning a funeral, planning visitations, planning other matters such as even the probate court process in order to get done what needs to get done in order to wrap up that family member's affairs. Because of that, it's important to make sure that you try to make that as easy of a process as possible for the individuals that you love. Another reason why people try to perform estate planning is to avoid taxes. I've already discussed about the federal tax returns for 2017 in terms of the estate and gift tax exclusionary amounts. As I said before, they are in the excess of millions of dollars a year. Ohio has repealed its estate tax. That is something that is not enforced at this point. It could be something that could come back in the future. If it is, certainly your estate plan may need to be re-examined, but I'm not going to discuss in depth what that will require. Another goal of estate planning is avoiding Medicaid costs, or perhaps preserving the sort of costs that you would want to preserve when it comes to Medicaid. There are exclusions of your Medicaid estate that can be protected with some estate planning and even pre-planning when it comes to funerals and the like. Again, this is not a Medicaid presentation, but that is one of the goals of estate planning in most circumstances. Another goal is to take care of your family. Certainly when it comes to estate planning, I'm kind of using the macro view of not only the assets that you have that are in your name when you pass away, but also other assets such as insurance, life insurance, benefits from retirement that are preserved in a way to avoid extended tax consequences or extended cuts when it comes to probate. Another goal of estate planning that often is not necessarily cited because we don't necessarily think that that's something that could come into being is to avoid disputes. As I said before, that if you haven't written an estate plan, the state of Ohio already has one written for you. That doesn't mean it's going to be something that everybody's happy with. But in most cases, if you are the individual that writes your own estate plan or that helps guide an estate planning attorney to make those sorts of decisions, then there's probably going to be a higher likelihood that family members are going to respect the decisions that you've made with your own money and with your own legacy when it comes to not only what your financial assets are, but also your priceless ones, such as photographs or collections. So without further ado, I'm going to actually present to you what those 4 documents that every family needs. Those 4 documents are the will, the financial power of attorney, the medical power of attorney, and the living will. Now, I'm going to discuss each of these in particular in terms of what each of these are doing, but there are requirements, as I said, as I may have indicated before, and if I haven't, I apologize, that are needed in order to make all of them valid. In all likelihood, you can't just pull out a sheet of paper and say, "This is my last will and testament," and sign it in crayon and not have it witnessed by any individuals. You could do that, but it will likely be very difficult to pass the challenge that probate court actually requires in order for a will to be valid. So I would hold off on that and actually try to get, not necessarily, it doesn't have to be perfect, but we want it to be good and something that is enforceable. Something that all these documents should have, particularly the medical powers of attorney and the living will, are HIPAA language. HIPAA is a federal statute that requires compliance when it comes to having somebody other than yourself actually obtain information regarding medical information involving you. That means that when it comes to these documents, it's important to have all these individuals have that sort of authority so that they are not kept guessing, and also so that they are not necessarily shut out in terms of the information or decision-making process if this is a situation where you may find yourself in the hospital. So let's go over the first document that we will be presenting on, and that is the will. As I said before, the will is a document that will dispose of what's called your probate estate. You have 2 types of assets: probate assets and non-probate assets. Non-probate assets are assets that automatically transfer to somebody else when you pass away. A quick example of that would be a joint and survivorship checking account, where if you pass away, the other person on the checking account is able to go ahead and use it at their own discretion. Another situation may be a retirement account or an insurance policy that has somebody else as the named beneficiary on that account, or a secondary beneficiary, where if you pass away, it transfers over to them. However, the probate estate is everything else that is actually in your name, in your sole name, when you pass away. In order to have a valid will, it needs to be constructed properly. What that means is we're looking at 2 specific requirements. The first requirement is that you're going to need to be of sound mind, and it shouldn't. You should be in a situation where your mental health or your capacity to knowingly state what your intentions are not brought into question. In addition to that, in the state of Ohio, the signing of your will needs to be witnessed by 2 disinterested people. That could be the attorney that has actually drafted it for you, as well as somebody else. The purpose of that dates back and provides a requirement that this individual is who they say they are, and because of that, this is what they are intending to do. In Ohio, a will doesn't have to be notarized. In some instances, it may be helpful in order to notarize it regardless, for simply the reason that if you pass away and you draft a will in the state of Ohio, you may not necessarily live in Ohio the rest of your life. You may be a snowbird. You may, transfer out of state with your job, and it is helpful to perhaps safeguard what those intentions are that you have in your will if you don't get around to acknowledging it in a new state. Now, that being said, that doesn't mean that it will automatically be admissible and everything is going to go in accordance to the way that you would have had it done if in the event that you were to pass away in Ohio. But it does mean that it will be helpful for whomever is going to ultimately administer your will if it's done out of state. So it's important to keep that in mind and kind of have that as a safeguard. Wills include just about everything when it comes to your probated estate. So you want to consider these 5 things when it comes to making sure that things are divided the way that you want them to be divided. That includes debts. Debts may mean instances such as, when it comes to the things that wills cover your debts. They cover gifts that you want to make. They cover what's called the remainder estate. They cover whom is going to be the executor and whom you're going to name as alternate guardians. When it comes to debts, debts are debts that you may personally have at the time of your passing. You can indicate exactly how those debts are going to be resolved, should there be enough funds in your estate to cover all of them, and also make sure that your intentions are preserved. Whether that's if you have enough proceeds in your estate to pay off the mortgage in your house, if that's what your desire is, so that your family can enjoy that. That is something that you want to make sure that you have drafted in your estate plan. In addition to that, the will covers gifts. When I say gifts, I'm being very, very broad when it comes to that. When it comes to saying that there is a specific piece of property that you have that you want to give to somebody else, whether that is a collection of Beanie Babies to your cousin, or if that is something along the lines of just a lawnmower. If the neighbor next door has helped you out with with mowing your lawn in the past, you may feel inclined to go ahead and give them your lawnmower. Anything that isn't a specific gift is considered your remainder estate. So once you get past all those specific gifts, that chunk that is left over, if there is a chunk, and hopefully there is, you're able to say how that is going to be distributed. If you're married, you can provide the remainder of the estate to your surviving spouse. If your spouse passes away, or if you're divorced, or encounter some other situation where you're not married at the time of your passing, you can have the remainder estate divided up amongst your children in equal shares, unequal shares. You can write somebody out of it specifically if you'd like. You can make sure that individuals are compensated the way that you want them to be compensated. It is up to you, and it's up to making sure that your attorney just understands it so that they're able to go ahead and draft that for you. In addition to that, the will can also name, perhaps most importantly, alternate guardians for your children. If you are a family member, if you have a family, obviously, if the two of you if you are married with your spouse would resume the situation as being the primary guardian for your children. If in the event that both of you pass away, or if one of you, one of you passes away after the second one, you can name individuals that you would want to be alternate guardians for your kids. And that's important because the values that you may have are not going to be the same values in terms of unique fit as probate court is going to look at. They are just simply looking for individuals that can raise the children in a safe, hospitable environment. If you're a parent, that may not necessarily be what your primary goal is, or it may not necessarily be what your what you would want in terms of your intentions. Specifically, just because a place is safe and just because a place is helpful for your children, it doesn't necessarily mean that that is where you want your children to be. So, your children may go to your sister, but you may be more comfortable with the children going to your in-laws. You may be more comfortable with it going to your cousin or another family member that isn't based strictly off of what the what the checklist is needed in order to kind of go through each and every family member piece by piece. So instead of going off of the list that probate court goes off of, you can create your own list in terms of how you would want to rank your family members in terms of alternate guardians for your children. So that's something that you would likely want to make sure that you have done in order to do that. So why would you want to have a will? Specifically because it will determine who gets what that is in your name at the time of your death. If you don't have one, it is a possibility to, it could actually create a delay in the probate court process, and it also ensures that it does not include non-probate property. As I said before, one example of it is joint and survivorship accounts. Another example could be trusts. Trusts are something that specifically, since it is titled differently in terms of legal name, it is owned by something else. What some people may not fully know is that a will can determine just about any property or any sort of access that you have. So your pets, I've seen people make pet trusts before. I haven't drafted one because if somebody tells me, hey, I want to draft a pet trust, I will likely look in their face and say that's a waste of money. But your values are probably different than my values, and I understand that. And if that's the case, I would direct you in the direction of somebody that may be comfortable with that. But if you don't feel that a trust for your pet is necessarily needed, you can go ahead and gift that pet to an individual in your family or a friend or some place that you feel that that pet is going to be protected. Another situation that a lot of people don't discuss or think about are passwords. Now with social media, you can actually state in your estate plan how exactly you want your social media footprint to actually be maintained, deleted, deactivated, and actually provide the executor with the authority to do that, the executor being the individual who will be taking care of your estate. And then again, one of the other things, as I said before, collections, stamps, what have you, that are, that is property. So I did go over this a little bit previously. Why have a will? As I said before, if you don't have one, Ohio's written one for you, so the statutes are going to dictate that. If you don't have one, it's going to cause a delay in the probate court process, and that may not necessarily seem that important, but if you are in a family and there is a mortgage that needs to be paid and there are bills that need to be paid, and in terms of lighting, electric, even funeral expenses, there needs to be some sort of clarity on who has to pay what, and more importantly, whomever is paying that they feel comfortable enough to know that they are going to be reimbursed or that they are going to receive some sort of value in order for that, whether that is to allow them to continue to reside in the home or to ensure that they will be repaid in the event that something gets paid off. Another reason why you would want to have a will, if you do not have a will, you cannot name the person in charge that you want to actually be in charge. And what that means essentially is that if you do not name the person that you want to be the executor or the administrator of your estate, the court is going to appoint somebody. And the rubric that they look for when it comes to that may be different than you. You may have a brother that lives here in town. He may be incredibly awful when it comes to finances, and they may appoint him to be in charge of putting together an inventory of all of your expenses. when it comes to your assets and your finances. He may be the last person on your list, but if he lives in Hamilton County, he may be more preferable than somebody who lives across the river, just simply because it's a lot easier to appoint somebody in that manner. And then, as I said before, another reason to have a will is to protect your children, to make sure that those things are taken care of the way that you want them to be taken care of. So when you go through a will, you want to take into consideration who will get what, who is going to be the individual that is going to carry it out. As I said before, that's called the executor. And you want to go through what sort of qualities that you would want when it comes to that. Much in the same way that you want to make those decisions when it comes to finding an accountant to do your taxes, when it comes to perhaps hiring an attorney, when it comes to anybody making important decisions on you or for your behalf. So you probably want to find somebody that is trustworthy, that's studious, and good with details. Those are qualities that generally make that probate court process go a lot faster and a lot more smoothly. In addition, in terms of considerations, you also want to consider who will take care of your children and whether or not that they're willing to. Your ideal guardian may be somebody that already has 5 kids or may even have 8 kids, and they may say that 8's enough and they may not want any more. And if that's the case, then you may want to name some alternate individuals where, if in the event they are not able to raise your children, that you're able to get somebody that is preferable to you, as opposed to somebody whom just passes the appropriateness test. So we're going to now look at the second document that every family needs, and those are powers of attorney. Powers of attorney in general are documents where somebody acts on your behalf for some reason or another. In order to have a valid power of attorney, when you sign it, you need to be 18 years old and of sound mind. The power of attorney needs to be properly notarized and executed in front of a notary. But when it comes to powers of attorney, it may not necessarily be something that is effective immediately. There are 2 types of powers of attorney. There's the springing kind and the non-springing kind. And by springing, I mean it can spring into effect when something occurs. For example, if 2 doctors say that you are incapacitated and unable to make decisions on your behalf, a power of attorney can go ahead and that you have previously signed become in effect and allow that individual whom you named to be your agent to make those decisions for you. And if in the event that we don't have that sort of springing provision in there, it is effective immediately unless it has that sort of language. Another part of powers of attorney is that the powers that you actually give somebody to act on your behalf can be broad or they can be narrow. It could be something just solely to allow you to go through a closing ceremony when it comes to purchasing a home. Or it could give you carte blanche in terms of what sort of decisions can be made in terms of your bank accounts, signing for checks, making medical care decisions for you on your behalf. It very much depends on what your desires are when it comes to naming an individual to act on your behalf. So there are 2 main categories when it comes to powers of attorney. Those powers of attorney are called a durable financial power of attorney, a durable power of attorney or a springing power of attorney. Those essentially, as I said before, mean that whether it is in effect until you say it's no longer in effect, or whether or not it goes into effect, or you can actually have people act on your behalf when a situation happens. And then in terms of powers of attorney themselves, there are 2 main sort of decisions that can be made. Decisions involving financial decisions involving your life, and then medical decisions involving your life. Each of those, based on what may be best, it may be easiest in order to have separate documents for each of them, because each of them have different requirements in terms of what you're contemplating and what you want to actually have done. So let's first look at a financial power of attorney. A financial power of attorney allows someone to act on your behalf, and it can be triggered by an act, as I said before. However, that person that acts on your behalf needs to act properly. If they don't act in a way that is in accordance to what you feel is owed to you in terms of a duty, then they have breached that duty, and they could be liable for perhaps some damages if in the event that they breach that duty. For example, if they have access over your bank accounts, strictly for the sole purpose for you going ahead and making sure that your rent is paid on the first of every month while you're out of town, if they go ahead and they loot that bank account and then they hightail it somewhere else, then they've certainly breached that duty. So, while they may be liable when it comes to that, it probably is helpful to make sure that the individual that you appoint as a power of attorney is somebody that is trustworthy and is able to make those decisions in a way that, hopefully we don't get into that situation. And then for some reason, banks, while there isn't a statute or a requirement under Ohio law to do this, banks, for some reason, I've encountered like powers of attorney that are 6 years old and younger. It just seems once you get past that 6-year mark, they will ask you to re-execute it. I'm not sure if it's a compliance issue, but I do know that that is something that you want to keep in mind, because they may say, we're not going to accept this power of attorney, even though the courts will say it's valid. You could duke it out in court if you want, I guess, but again, that's probably going to be more time consuming and more expensive than just to simply reignite it and reactivate it for the next 6 years. So why would somebody need a power of attorney? Someone would need a power of attorney to ensure that somebody that you know, like, and trust can manage your finances. Does not require a lot of additional paperwork. It allows for sales of joint real estate and property, and if you travel, as I said before, it may be needed. When I say it does not require additional paperwork, if you are able to go ahead and make those decisions and appoint somebody on your behalf, you could delay or perhaps avoid the requirements of what's called a guardianship, which is more of an involuntary way to have somebody act on your behalf. One of the reasons why you would want to perhaps avoid that is because it will not necessarily be somebody that you know, like, and trust. It may be a total stranger. It may be somebody that you may know, but you may not necessarily like and trust. Or it may just be somebody that you don't trust in general. And the purpose of that, in addition to that, is that guardianship can ultimately lead to a lot of expenses. There is an ongoing process that needs to be updated in terms of probate court proceedings, and there may be a requirement for a bond to be posted based on what your net worth is. That can cause a lot of administrative and financial headache for you and your family as well. In terms of financial powers of attorney, if you're a married couple, it sometimes is helpful to have both have one valid for your spouse, so your spouse can go ahead and have it executed and valid in order to go through situations such as selling joint real estate and property. If you run into a situation like you may have with your credit being hacked by an entity such as the individuals responsible for Equifax, somebody can go ahead and perhaps that you've placed to be on your power of attorney to request that your credit be frozen in order to make sure that ongoing things aren't withdrawn. It can be as flexible as possible. I normally find clients are interested in having a durable power of attorney for their spouse as long as their spouses are alive, and then in the event that their spouses pass away, to have one that kind of reverts back to having it become in effect when when something happens. So basically, husband and wife continue to have an ongoing durable power of attorney, but when husband passes away, wife's power of attorney that perhaps her son is the new agent on doesn't go into effect until something bad happens to wife. The other document in terms of powers of attorney that you want to look at are what are called medical powers of attorney. A medical power of attorney is one that allows you to make choices that you want in terms of medical treatment on your behalf now, in order to avoid, as I said before, of the costs associated with guardianship and bonds, and it's a lot less onerous than guardianship. There are some duties like a financial power of attorney that are that the agent is responsible for. That includes acting in good faith, acting within the scope of authority under the medical power of attorney. For example, if the medical power of attorney says that you want treatment or you want decisions made regarding, surgery, they can't go ahead and make decisions over other types of treatment. And then there's an expectation that the actions being taken are within that individual's best interest, and it also preserves the estate of the individual whom is what's called the principal, or the person that is assigning somebody to be their power of attorney. Ultimately, a medical power of attorney is a document that substitutes your judgment for somebody else's when you are unable to fully voice what your decisions are. You would want a medical power of attorney so you're able to have a say over your medical care, because in addition to just naming somebody, the power of attorney will also place the sort of restrictions and kind of voice what those desires are in terms of what how you want that individual who is going to be your power of attorney to act. If you don't choose someone, the state will choose somebody via guardianship, and it allows you to prepare for things that you can't predict. One of the important situations for that would be if in the event that you have complications with surgery, if in the event that you're under anesthesia. Those are all things you've likely encountered when you check into a hospital. They will ask you if you have a valid power of attorney, and they'll also ask you about whether or not you have a living will. We'll go into a living will in just a moment. But one more thing that I want to touch on when it comes to medical powers of attorney, if you have children that are college students, it's probably important for them to allow you to have a valid power of attorney over them. And of course, if they're over the age of 18, they need to be of sound mind and voluntarily do it. But as a practical matter, college students having powers of attorney are helpful because it will allow parents to go ahead and make the sort of ease in terms of ensuring that they have the sort of prescriptions that they need, because even though that they are 18 and viewed as adults in the eyes of the state, in many situations they may not actually act like full-fledged adults, and there may need to be some sort of I guess training wheels, for lack of a better term, when it comes to that. So when it comes to living wills, that is the last document that we're going to be looking at. A living will is a right, allows you to articulate what you want to have done to you when you are incapacitated and you are at the point where individuals have decided we are at the point of no return in terms of you being able to go ahead and resume consciousness and be able to say what you want to have done. That can include your right to refuse treatment when it comes to palliative care, when it comes to something beyond comfort care, or even comfort care itself. It addresses instances such as life support measures, whether ongoing hydration is something that is something that you're concerned about. It also addresses issues such as whether or not you would want a feeding tube installed. If you have a living will, you can actually say whether you want it or whether you don't want it. And then you can always have the ability to amend your living will over time if your desires and if your beliefs change over the course of time. Living wills generally expire after 7 years, so it is something that you want to reevaluate over time. And more importantly, if you have a valid power of attorney, a medical power of attorney, the living will supersedes that power of attorney. What that means is that if you have a living will and it says one thing, and you have a power of attorney and it says something else, Even if you sign this power of attorney before you sign the living will is still going to be controlling it. Doctors and medical experts and courts will look towards the living will before they look towards the power of attorney. In addition to that, it also allows you to name the doctors that you want, or it also allows you to list the individuals that you want doctors to contact in the event that you are in a situation such as requiring a living will. That way your family members are aware of the situation, your friends are aware of the situation, they can start planning accordingly. As I said before, the reason why you would want a living will is so that you have the ability to say something when you can't say it. It also allows to ensure that your desires and your beliefs are adhered to, because if you don't, then somebody's going to make a best guesstimate over what they think your decisions would be. It also reduces your stress on loved ones, much in the same way that a will goes ahead and allows a sort of peace of mind that for family members to say, well, at least that was his or her intention. A living will also makes sure that your family members are not the ones that have to make that excruciating decision. Rather, you're able to make it on the way that you want it on your own terms. Now, in order for a living will to take effect, you have to have two physicians examine you and determine that there's no possibility of recovery, and death is likely to occur without In order to have a living will, two physicians need to examine you and determine that there's going to be no recovery for your particular ailment, and death is likely to occur without life-sustaining treatment. What that means is that if the physicians do nothing, then you will pass away. That is when they determine that a living will is likely going to be needed. In terms of terminal conditions, it needs to be something that is irreversible, incurable, or untreatable. So in order to have a living will take effect, one of those two things can exist, or both of them can exist. In order to make sure that you want them in that particular circumstance, make sure that you draft for it, make sure that your attorney is aware of it, and make sure that the documents are up to date and that you sign it. So, in summary, it's important to make sure that your family is protected in the ways that we've discussed today. There are essentially 4 documents, all of them requiring HIPAA language to some extent, to make sure that you have on hand to make sure that your family and your legacy is protected. That's your will, your financial powers of attorney, your medical powers of attorney, and your living will.
The Law Library provides a monthly newsletter and a bi-weekly topical updates to keep our subscribers up to date on the latest legal news. This video is to show you how you can sign up for these emails on our library website. Starting on the library's home page, you want to go to the Services tab and go down to Mailing List. Once you're in the mailing list, you're going to enter your email address, your first name, and your last name. And then you're going to pick which mailing list you would like to receive an email. Enter the security check information. And click Sign Up. Scroll back up to the top and you'll have a notice that you've been added to the mailing list. If you have any problems or questions with receiving your emails, please call the library at 946-5300.